everyone. I'm delighted that you're here today and so grateful that you're taking the time to um, spend your midday with me on this beautiful Thursday in Colorado. Um, let's get started. Um, this webinar concerns the dangers of AI wills. Um, these are not hugely circulating at this time, but I anticipate in this webinar is intended to acknowledge that we anticipate as lawyers, as estate planners, that there's going to be a lot more AI generated wills in circulation. Whether they will be effective or not will be the subject that I predict of much litigation to come. And I will explain why in this webinar. So about me, my name is Kate Silburn. I own Rocky Mountain Elder Law in Lakewood, Colorado, and I have been in practice for 26 years. I've had my own firm for, it's going on 7 years. I am also a hospice chaplain and a hospital chaplain for a long time, longer than I've been a lawyer. And I care deeply about the process of estate planning and that people get good, solid documents in place in their estate plan and that reflect not just their wishes for the disposition of their assets, but their wishes as they decline, as they have a last illness, as they have dementia, all of those other issues as well. My passion for estate planning is rooted in a sense that people should make as many decisions about their welfare, their care, their finances that they can while they can. And so with that, let's begin. AI, as many of you know, is not all it's cracked up to be. We are facing a situation, and this is just an example. Yesterday, I was at a meeting and a mortgage specialist told me that someone brought in a ChatGPT mortgage document. Now, it may seem absurd, but it's certainly no more absurd than creating a will generated by ChatGPT. I know that AI generated wills seem quick and affordable. After all, ChatGPT will do it for free. But there are certain formalities that a will should be executed with, and the AI wills are generally not executed with the requisite formalities, nor are LegalZoom wills. Oftentimes, people generate these wills and then they notate things on them or cross out things and then sign them at the bottom. These crossouts and notations can nullify a will. That's just the formalities of execution. It's the content of the ChatGPT will that concerns me, or lack of content. To say that it's bare bones and covers solely a disposition under your for your assets is an understatement, because a will isn't just paperwork. It's your legacy. Mistakes in the will or wills that don't cover contingencies, such as remote contingent dispositions, such as in my wills, I have 2 trusts that are contingent trusts for minor beneficiaries or for people who are disabled at any age, to prevent them from losing their benefits if they inherit. ChatGPT wills ignore all of that. including digital assets, any provisions concerning taxes, all of the things that make a will a solid, enforceable document. And of course, we know that mistakes in drafting, even wills with attorneys, competent estate planning attorneys, have mistakes, and mistakes can leave your family with confusion and conflict. So, what I'm seeing in my practice, I am seeing more and more AI tools being utilized by lawyers as well as lay people. There is a place and time for AI. AI can be a fun way to explore things, get answers. It is not a place to do legal documents. For instance, lawyers who have used AI to draft motions, AI has hallucinated cases to support their position or proposition in a motion. Those lawyers have been disbarred. AI can be a really helpful tool for use in things like calendars or managing an email flow, but don't let AI write your emails. I can spot those a mile away, and I have been known to ask opposing counsel to knock it off, to get to the point. Um, these platforms can be very useful, but the promise of convenience does not guarantee accuracy or legal enforceability. A flawed will or a shoddily prepared thin document can impact generations of your family. Again, I've yet to see AI generated wills or legal Zoom wills that don't have additional notations or that have followed the requisite formalities for execution. These are all flaws that can impact generations of your family, leading to unnecessary litigation. So why do AI wills fall short? Estate planning is more than filling out a form. It's the key to protecting yourself and your family. I often call an estate plan a love letter to the people who love you. AI completely misses the personal, emotional, and legal nuances of that work. It is, again, a love letter, not a template. Oftentimes, asset pictures and the distribution of assets is far more complex than what an AI generated document can encapsulate or memorialize. This is very important to remember. I've had the question from people, is an AI will better than nothing? And I'm not sure that it is, because it can lead to confusion, unwarranted expense, and a lack of clarity in the people you're trying to leave your property to. So, what are the hidden risks of AI wills? Well, to begin with, a simple will, even if it's thinly drafted and doesn't encapsulate all the requisite provisions that a Colorado will should have, it misses the bigger picture of estate planning. And what I mean by the bigger picture is that, for my purposes, the most important documents you sign are not necessarily the ones that dispose of your assets. An AI will, of course, does not uh, give you the requisite powers of attorney. There's no living will or advance directives. There's, of course, no accountability. If the will fails, if for some reason it's the names are filled in a way that doesn't capture the actual person's identity of who you want to leave your property to, there's no one to help when things go wrong with an AI will. And that's why I said I anticipate a lot of litigation around these wills. Um, these are kind of cookie cutter, two-page things that um, do not reflect a unique life and that does not fit a generic form. Further, AI wills have incredibly vague language, which leads to family disputes and heartbreak. So we want to be extremely careful about just punching in data and having the AI will spit back a kind of two-page document that doesn't address, again, those contingencies and those requisite provisions you should have in every will. And that includes everything from digital assets to taxes, etc. In my view, what's the elephant in the room with an AI will is the human touch. Estate planning is about relationships, not just documents. And conversations make all the difference. Not only conversations with a competent estate planning attorney, but conversations with the people you love and who love you, and really being transparent about what you intend to do with your property, what kind of property you own. When you do an AI will, there's not that inventory that's done with a competent estate planning attorney. And by inventory, I mean, how are your assets titled? How do we want to effectively distribute them? Do we want to, does an AI will or can an AI will check title, not just to accounts, but to real property? Is it appropriate for you if you have multiple real estate holdings to have a trust? Is it appropriate if you have a business to have a trust? AI wills completely miss those aspects of people's often more complex than they think estates. So let's think about, just for instance, that you have children who are minors. If something happened to you tomorrow, who would raise your children? Have you asked them, those persons you would like to raise your children, if they're willing and able? Have you memorialized the selection of guardian in a will or a separate document selecting a guardian? Does your chosen guardian share your values about education, religion, and discipline? What if your first choice can't serve or predeceases you? Who's your backup, and do they know? How would you want your children to remember you? What stories and values matter most to you if something were to happen to you? This issue of minor children is very, very important. An AI generated will, the ones that I have asked various platforms to do, don't even ask the names, much less the birth dates of children, which would trigger, from my perspective as an estate planner, the idea that, hey, we need to plan for these minor children. We absolutely have to have a trust. We absolutely have to have guardians. And again, the wills that I do have a built-in contingent trust for beneficiaries who are under a certain age. So it's so important to think about minor children when doing a will. So let's think about your family. This is something that you can't necessarily plug into an AI platform and really get the kind of feedback you need from a trusted planner or advisor or even other family members. We need to think about if there are family members who don't get along. How might that affect the estate plan? How does it affect your selection of an executor or a personal representative? Some of the AI wills that I've seen don't even have an executor named, much less a trustee or anything like that. Um, are there children in your family from multiple marriages? How do you balance fairness with your current spouse's security? Um, is anyone in your family struggling with addiction, financial irresponsibility, or mental health challenges that require protective planning? Is there anybody with a disability of any kind? It would be disastrous for someone receiving disability benefits to get a windfall inheritance. So that's why another aspect of the planning I do always includes trust for someone who's on disability, because we never want to lose that stream of benefits. AI misses that completely. Um, are there family members you'd prefer not to involve in your healthcare or financial decisions? That's a really important question. Um, we want to always have powers of attorney for medical and financial in place. If you're over 18 and don't have a medical power of attorney, I do them for free for the community. That's how important I think that document is. Um, we want to make sure that you have the right people in place, not just as your personal representative under your will, but also a backup, maybe a third backup. But then we get to the whole idea of the estate plan on the whole. Who is going to manage your finances if you become incapacitated? Who's going to make healthcare decisions for you if you can't? AI planning, in my experience, misses those issues completely. So let's think about your care. Again, a will covers only the disposition of your assets after you die. It is not an appropriate document to insert who you nominate as a power of attorney. You don't do add-ons to a will. A will comes to life when you pass away, plain and simple. So let's think about your care before you pass away. A good estate plan always contends with that question, which is, what does quality of life mean to you? When would medical intervention no longer align with your values? Who do you trust to make healthcare decisions if you can't? And have you discussed your wishes with that person openly? I know these are uncomfortable conversations to have and difficult conversations to have, but they are critical conversations to have. One needs to think about if they want to die at home, in a hospital, or in hospice care. One needs to think about specific medical interventions you'd refuse or insist upon. The document that captures a lot of this is the living will or advance directive, and that's a very specific Colorado statutory form. These are not issues you want to plug into an AI platform. We want any advance directive that you do, or living will as it's called, to be enforceable under Colorado law. And that's the statutory form. In addition to that form, I also do dementia planning. And that's a topic that many, many people now in their lives are touched by dementia, whether it's a neighbor, a friend, a family member, a spouse, a sibling. I feel it's important, again, for people to make as many decisions about their care in advance of decline that they can make, and to make those choices consciously and Um, Make it clear to the people who love you that there's a guideline, there's directions should this circumstance arise. Um, an living will is a critical component to any good estate plan. Again, it's not just the stuff where it goes after you die, it's what happens well in advance of your death and your decline and your last illness. So, thinking about what matters. Um, an AI will contends only with um, the one person or few people that you want to leave your money and real property to. It doesn't contend with personal property. It doesn't contend, and that's the tangible stuff you can touch. Um, so it's important to think about with your estate planner, what do you want to pass on besides money? What family stories, traditions, or life lessons? This is a kind of planning called an ethical will. And I love to do this kind of work because oftentimes this is the way in to really get to talking about the stuff that really, really matters to people. Um, I think it's important to investigate and explore how you would describe the values that have guided your life. And that can often lead to an examination of what charities, causes, organizations reflect your deepest beliefs, and should those be part of your legacy? Many, many people leave gifts to their college or leave gifts to their church or some kind of bequest to organizations that really mattered to them in their life. And this can bring an enormous sense of peace and also satisfaction. Um, One of the things, also the kind of planning I do is looking at your the disposition of your body and your funeral or memorial service. A lot of people don't want to touch this, but it's so important to make a decision about whether you want to be buried or cremated and whether you want a funeral or memorial service. And I even go further and really look at elements of your memorial service. As a chaplain, I have quite literally seen fistfights over what was mom's favorite song or hymn or poem or scripture. And we want to leave directions, as many directions as we can um, r- really grapple with. Um, I think an important exercise for every person is to write their own obituary. That may sound very bizarre, but it can be really helpful in getting at how we want our memorial service to go and what elements we want in our memorial service. Um, these are parts of an estate plan that are often ignored or missed, but certainly missed if we're plugging our solely the disposition of our property into an AI platform. So let's think about your situation. I touched on before if there was a beneficiary in your estate that is receiving government benefits. This cannot be um, emphasized enough. We do not want to disqualify people receiving disability from their benefits by leaving them a bequest under our will. We also want to contend with issues that are specific to owning a business. Do we want that business to continue? Do we want a particular child or friend or associate or business partner to have the business interests? Do we want our share of that business to be inherited, to be sold, to be liquidated and wound up? Who will do the winding up? Who will assist in closing down that business? This kind of planning is often ignored, and many, many business accounts or business interests go ignored for years after a person dies because there hasn't been any planning around it. Another important issue is whether or not you have assets in multiple states. We always want to set up a trust to hold out-of-state real estate. The reason is we don't want to have to open another probate in another state in addition to Colorado. So we want to make sure that any assets, real estate assets, are controlled by a trust that are out of state. And then, of course, there is the personal property. A lot of people have certain things that they'd like to go to certain children or grandchildren or a friend or a sibling. Those specific items can be jewelry, heirlooms, photographs. There's often one child who's like the family record keeper or the genealogist who probably would love to have the photos. Um, these items, I I did an estate recently on the Western Slope that had a lot of that was a ranch and had a lot of saddles and horse tack and that kind of thing. It was very important to the person doing the estate plan that those items went to a granddaughter who was a horsewoman. Um, these things can carry a lot of emotional weight and should be contended with. It should be thought out who should receive them. And there are issues of fairness and equity that go into it. But also, it's remarkable how much these things can mean to the people they're given to. And it's dangerous to ignore those elements of an estate plan, which often can carry more emotional weight than any other. So, in thinking about fairness, what does fairness mean in an estate plan? Um, One of the things an AI platform never captures is the dynamics of a family. If you're leaving different amounts to different people, do you explain why in a will? Do you just simply disinherit someone? I always think that's a very bad idea. It really opens the estate to challenge, to a will contest. So it's better to leave a nominal sum to the person who's getting less and make some kind of statement about why. It can be as simple as their conduct. It can be as simple as they've received advances on their inheritance over time. Those kinds of things can be extremely helpful in silencing any kind of challenge to an estate plan. It's important to recognize if there's decisions you're making that might surprise or hurt someone. And it's important to communicate your reasoning in the document itself. But that needs to be done very sensitively, and it needs to be done in a way that really reckons with potential legal challenges to that document. And then we need to think about who you would trust to mediate if family conflicts arise after you're gone. Um, and that means even having a clause in your will that any dispute arising under the will should be mediated prior to litigation. And I think that that can be an extremely helpful kind of red flag to anyone who's going to challenge a will. So, what can you do now? Well, again, I hope I've made it clear that an AI generated will is not all it's cracked up to be. Um, what I recommend is working with a qualified, competent estate planning attorney who does not only a will, but also the very important critical ancillary documents that include your powers of attorney, a living will, uh, and a trust if necessary and warranted. Um, all the things that make up really a good estate plan and that don't ignore the potentiality for decline and um, and serious illness. It's so important to talk to an attorney that you trust and your family about what you want. And in doing so, you can clarify and make sure that your legacy reflects your true wishes, rather than a simple kind of cookie cutter approach to just doing a will. I do not recommend that approach under any circumstances. So if you're interested in estate planning, we have here a QR code you can scan. And what you will find is two documents. One is the critical elements of an estate plan, kind of a review of what I've gone over today, but really looks at what you want to have in place um, to secure your legacy, but also to secure the kind of care you want in last illness. Um, and then there is a handout concerning questions to ask before you die that AI cannot answer. And I hope that you'll avail yourself to the QR code. In the meantime, I'm happy to take any questions. And I again want to thank each of you for listening today and for attending this webinar. Your presence means a lot to me.